Good afternoon. I'm Yami Virgin here in San Antonio. We are reporting again on the Suzanne Simpson murder case. Mariah Medina is with me today. Thanks, Mariah. And also John Hunter, criminal defense attorney. And we appreciate having you here to put everything into context. We were back in court today. And Mariah, tell them a little bit of why we were in court today, part of the reason.
So Brad Simpson was seeking to have contact with his kids, all but one of the children he's now allowed to have contact with. The judge decided the youngest of the children is 5 years old. That is the only child that Brad Simpson cannot have any contact with. The second oldest, I believe, is
Correct.
15 years
15
old and
years old.
has voiced that he did want to have contact with his father. The two adult children have said not at this time, but they wanted to leave the door open. And so the judge allowed that and changed the order from no contact to no harmful or injurious contact. And he obviously left the no contact order in place for Mr. Cotter, who is Brad Simpson's longtime business associate, who is also charged in connection with this investigation. But we also saw that the defense attorney for Mr. Simpson brought to light that the judge's gag order had been potentially violated. Yami, I don't know if you want to elaborate more on that. You might know.
Yes. So we were all a little bit shocked. You can imagine. We're sitting in court. Some of Suzanne Simpson's friends came in. They sat down. Her sister came in alone. She was the only member of the family that was in court today. And at that point, when the judge said, I'm hearing that some people may have violated the gag order, which means you're not allowed to talk about the case, he called up both Bart Simpson, who is Brad Simpson's brother. He wasn't in court, and who came out in a YouTube yesterday. It was about 40 some minutes long. And they brought it up while they were doing the YouTube that there was a gag order, but there were segments of it that some people would say he did talk about the case. And he also then asked for Teresa Clark, her sister, to come up. I mean, we were all sitting in court. I know I felt bad for her. She was visibly shaken.
Oh,
She
yeah.
seemed to be crying. Her voice was crackling. She was standing only a few feet away from the man who allegedly murdered her sister. And at that point, the judge made some comments, and maybe you can go back a little bit and talk about what the judge specifically said.
So the judge essentially told Teresa, nothing bad is going to happen. Just hear me out for a
There
little
she
bit.
is.
And explained to her that the reason why he instituted this gag order was to preserve Brad Simpson's right to an impartial jury and a fair trial. Teresa was extremely apologetic, and obviously just a few feet away from her is the individual who is accused of taking her sister's life. Something that she told the judge was that this has obviously been very emotional for her, but it was extremely interesting to see this play out because gag orders aren't really common in Bexar County, as Mr. Hunter previously explained. But John, what are some of the other remedies, that the judge has available to him should another violation continue or occur, rather?
Well, I mean, he's going to have to tailor the remedy based upon the significance of the violation, what specifically was discussed, how meaningful of an impact does it have on the case, and he'll have to weigh his options from there. His options could be, in the most extreme form, contempt of court, which could be carceral punishment, a fine. So it could be very serious. There's also a more perhaps reasonable approach for maybe a less serious violation of the rule, which would be a sanction. I mean, it could be either a financial sanction on the witness themselves, or given the fact that in all likelihood the witness that these witnesses in particular would be called by the state, the judge could invoke an exclusionary sanction so that they can't testify. They won't receive their evidence. It would be handled in that sense very similar to how violations of the rule, which I think is 3606 of the code, operate. If we find out that a witness that's been placed under oath during the trial has communicated about their testimony with another witness or with somebody other than the lawyers in the case, then the judge is going to have to make an inquiry to determine what specifically was discussed. Did it go to the heart and substance of that person's testimony or some other essential fact of the case that could have modified that witness's testimony, and then go from there. But yeah, I mean, probably the most middle of the road thing to do would be exclusion of their testimony.
So I did want to ask though, just you've read the gag order, and it's my understanding something similar had been put in place in a criminal case in Houston, you said?
Right, in Houston, about several years ago, but not that long ago, really. The Houston Chronicle filed a lawsuit in a high-profile criminal case seeking to undo a gag order on the basis that it was infringing on the paper's ability to exercise its First Amendment right. And the court rejected that argument, said, that really this isn't a violation of your First Amendment right because it is narrowly tailored to the specific interests of the defendant, his right to a fair trial. And so even under a strict scrutiny analysis, even under the assumption that any restriction on a person's First Amendment rights is unconstitutional, the court found that it was an appropriate use of the judge's power to issue a gag order. That order, as far as I can tell, is almost verbatim the order that Judge Perez issued in this case. And that makes sense because it's a tried and true, the language is tried and true, and it's been affirmed and approved of by an appellate court. And the 14th District is, they're theoretically all equal, but the 14th District is a very well-respected, well-regarded court in the state of Texas. But understand, that's the press challenging it. If an individual party or a witness were to challenge it, the outcome may be different. It'd be hard to say. I could see how an order that's trying to affect the conduct of so many different people could be both perfectly legitimate and constitutional for some, or maybe most of the people it covers, but in some specific instance, maybe it's going too far, or it is a prior restraint on their right to express themselves.
So when the judge had Teresa up there, he said, whatever you did, don't do it again. At that point, we're all going, what did she do? The only thing that we had seen was a post that she had done, I believe, a week ago. And there was a picture of her sister when she was 5 years old. I mean, where's that line? Where is that line?
Well, it's hard to figure out. And again, the judge is going to have to discern how much he has to do to fully enforce the rule based on the violation as he encounters it. What the judge did is a very kind and gentle approach to this issue. He has the full power to hold her in contempt if he believes that she's violated the order. He's not doing that. He's just letting her know, you've given evidence in this case. You've spoken to the police about it. You're subject to my gag order. Don't do it again. And that needs to be driven home, right? Otherwise, there's going to be a lot more tension. There's going to be potential litigation about it. That's going to complicate matters for both the defendant and for the prosecution.
It does complicate things a little because after the hearing had ended, I went up to the bench and I had asked the judge, I'm seeking clarification on your gag order. Does this prevent law enforcement from providing any substantive updates in the case, whether that be through press conference or whatever means that they normally communicate with the press about this case? And he said, yes, that the gag order does apply. And when I came back to the newsroom, I had communicated that to my boss, and he was even surprised that would seemingly apply. And it seems very broad, but I mean, in this case, you're saying that it's particularly narrow.
Right. I mean, it's obviously narrow to this specific universe of facts in this specific case. And it's not interfering with public officials' ability to do what's prescribed by law for them to do. For example, if they find her body, then there are going to be matters of public record related to that the coroner process, the death certificate, those sorts of things will be available, and they'll be published the way that everyone's records are published at their death. The press is going to have to be dogged to keep up with that and make sure that they're following what is being reported in the ordinary course of business. But it does prevent the police from making it into a spectacle, which they're prone to do when it's a high-profile case, right? Oh, we found a body. Let's bring out the stage. Let's bring out the podium. We'll decorate the room, and we'll have 25 people there. And we finally found the person. And it's a little bit gratuitous, and it's a little bit patting themselves on the back for a job well done, or a perceived job well done, and it's unnecessary. And it just stokes the fire more of what is already a really sensational thing, and that jeopardizes his rights. It's really not that different from a gag order that would be used to try and prevent the police from staging a perp walk, which is a routine problem we have, right? I mean, the booking process, especially if someone's surrendering to post bail in 5 minutes, should not be the kind of spectacle that it's often turned into. So, I mean, I can see the frustration, and I can understand that it will have long-lasting consequences on how the press can report the issue. But I mean, I think under the circumstances, it's.
But I think, I mean, we're at this point. This story has gone national. It's beyond a story. This is a family's life. This is the story of this family. And at this point, do you really think that he's going to be able to get a fair and impartial trial, not just in Bexar County, anywhere in Texas? Most people have heard of this case.
It's going to be very difficult, without question. It may not be impossible. And I mean, there are a lot of variables to that. As it stands now, if the trial were to be held tomorrow, probably the answer to your question is definitely not. No way. But trial won't be held tomorrow. There is still a process that's going to unfold. And with the benefit of having at least some kind of a shield of the jury pool, potential jury pool, from a constant flow of information, which may or may not be accurate or need amending at a later date, there is a hope that by the time it's showtime to actually have a jury impaneled, that if there's anything that can be done to present his case favorably, argue his case favorably, they'll be ready to do it.
Yami, to your point, somebody commented, "Good evening from Alberta, Canada." I did want to ask though, John, do you think that, or do what effect, if any, do you think it has on the case when the biological brother of the defendant is saying, my brother made a lot of mistakes. This is domestic violence. We want him to tell the truth, tell us what he did so that he can find grace. Do you think that those have a prejudicial effect? And is it so substantial that it almost tilts the cards in favor of Mr. Simpson or Brad Simpson?
Do I think it's favorable to Brad Simpson?
Just in terms of any sort of appeals, or because I know you work on appeals as well, but I mean, just in terms of making those arguments down the road.
The whole appeal of him saying, John, my brother, do the right thing. What does that tell you? That tells me that I believe you did it.
Right.
So do the right thing.
Well, and I think it's a maybe subtle, maybe not so subtle comment on his decision to remain silent. And it drives home what is often a big struggle for defense lawyers, which is getting people to appreciate that while keeping mum and not discussing something and not coming clean with whatever it is you've done is socially not acceptable, or at least frowned upon, looked at disfavorably. It is a constitutional right. It is as fundamental to being a human being as you can get. It is the way our system protects people from coercion and from being compelled to give evidence against themselves. And it's a sacred right. The founders considered it a right that was given by God. And so by continually pressing that point, I think it is a deliberate attempt to try and get the jury pool to think that if he's never going to speak, if he's never going to testify, that should be taken as evidence of his guilt. And that's just not the American system. Can that be overcome when a jury's picked? Yes. I mean, there are plenty of people in this country who do recognize and appreciate why we have that rule, that it protects everyone, not just Brad Simpson. And the struggle will be to find those people in jury selection and to weed out and excuse the people who won't follow the law, because they're not, if a juror holds that opinion that his brother is essentially inviting people to endorse as their own opinion, they're not legally fit to serve on a jury in the United States.
So Jordan's coming back from Uvalde right now. She's usually here with us. She wanted me to ask you, what are some of the potential consequences the judge could impose for breaking the gag order if family members continue talking? So what's the most extreme thing you've heard of?
Contempt. I mean, contempt, which comes with a jail sentence. I mean, it's a, there are two kinds of contempt. There's civil contempt and criminal contempt, and there are lots of nuances to that area of the law. The basic idea is a criminal contempt is purely a punishment for having done something that is in direct violation of a court order or some rule of decorum of the court or something along those lines. A civil contempt is usually coercive in nature. The idea is we're going to hold you until you capitulate and follow the court's order or do the things that we've asked you to do, to behave yourself in the way that the judge expects. So that would be the most extreme. Will that be done? It will depend on, it'll depend on the severity of it. If family and people who are witnesses in that loosest sense of the term, because they could be called at punishment, or they may be able to talk about something very general like Mrs. Simpson's, habits and patterns, her daily comings and goings, but nothing about the facts of what happened that day, that night. If it's a witness along those lines, I think that those people should probably take the order very seriously, read it very carefully, think about what they're doing in the greater context of this. And if they feel like they cannot abide by it or will not abide by it, I think they probably need to involve themselves in the legal process and challenge it in a legally appropriate way, like a writ of mandamus, something along those lines. They don't want to be challenging it as a writ of habeas corpus if the judge has imposed a contempt order against them. So, I mean, that would be the way to do it and handle it correctly if they feel like it's just essential. And I mean, I can't judge from their perspective. What they're going through is awful, and they're suffering and they're angry, and that's all human. It's understandable. Well, I have my deepest sympathies to them, but this is a very high stakes poker game. And
Definitely.
I mean, if they really want to see Brad Simpson found guilty, they need to make sure that the system works fairly, because otherwise they jeopardize the whole thing.
Let me ask you, for the two adult children, they're both college students. I can't even imagine. I know the oldest one has gone on social media and posted that feeling of she is now the voice of her mother. She is the light of her mother. Are we basically telling a victim, because she is a victim of the circumstances, to stop talking and not to be the light of her mother and not to be the voice for her mother, who may no longer be here? And that's what we're being told now, that she was murdered.
Right.
I mean, how do you balance that out, telling a victim's child you cannot talk about your mother?
Well, I mean, it's a horrible thing to have to ask. And again, I mean, I think everyone involved understands the weight of that. There are some interesting questions that are posed by specifically what you're describing, which is someone commenting on social media. The gag order's design is to prevent these people from going out and having their words used as fodder by the media to put forward a story, to advance the narrative, to fit that into the puzzle of how the media is trying to solve the case from their perspective. But I mean, does the gag order prevent someone from going out on the street with a sign saying so-and-so murdered my mother, or I miss my mother, or I'm miserable and I just want to die, I'm so sad? I mean, they have First Amendment rights. They have free expression. Social media is basically a digital street corner where people say whatever's on their mind. Is it covered by the order? I don't know. I'm sure that they would like to, and I'm sure that one reading of it is that kind of stuff is covered. There could be a reading of that order that says that isn't covered, because it's just that person's expression without this third-party intermediary. But again, those are the sorts of issues that probably for the benefit and well-being of everybody should be addressed with the court in advance. And the court has even said in the order, he's amenable to altering it. So the approach that would strike me as being the most prudent would be, if you have something to say and you need to express it emotionally for whatever reason, go talk to the judge. Go address it to the court. I don't even know if that necessarily would require hiring a lawyer. It would just require having the wherewithal to go and approach the issue.
Right.
Because otherwise, the only way that the answer that my question gets answered about is social media a violation of the gag order is in a proceeding to decide whether contempt, exclusion of the evidence, some other remedy is going to be applied to that violation.
Then it's too late.
By then it's too late. The damage has been done both to the integrity of the case and now the fallout of that. How is the judge supposed to react? He can't just sit by forever and let people thumb their nose at the order and let this one skirt and let that one skirt and so forth. Eventually he's going to have to put his foot down or the order will have no weight.
I did want to ask, I read the comments afterwards and for days on end for any of these lives that we do. And somebody had mentioned that, the media does more harm when we cover these cases. But I want to get your take as a criminal defense attorney. Is it truly, and feel free to speak your mind. I mean, truly, I
don't have a gag order with us.
Here in the Lion's Den, yeah.
Right, yes. Here in the Lion's Den. No. I am very interested from your perspective. Do you believe that any media coverage prejudices a defendant's right to a fair trial? For example, this live. Do you think that it could potentially impact Brad Simpson's right to a fair trial? I really am interested in your take.
Well, look, the first thing is, if a case gets attention, it gets attention for reasons that are typically pretty organic. I don't think that we're at a point where we can accuse the media of steering the ship so that certain cases get highlighted solely because the media wants to influence the outcome of that, right? The media is reporting on things that they think the public will want to know about. So it's sort of a chicken and the egg situation, but I think that obviously a crime or an alleged crime happened before the media ever got involved. And so the media is just doing its job in that sense. Now, can the media hurt this process? Absolutely, and they have on millions of occasions. But there are really nuanced reasons for that. For one, I think that a lot of journalism, and I was thinking about this the other day, is this maybe like the product of the Hunter S. Thompson era of journalism, the gonzo way of thinking, but like the idea of trying to be rigidly objective and not trying to curry favor with either position, but just reporting the facts is a very hard thing to do. And increasingly, I think people who consume media want someone to be championing a point of view, to pick a side. Mm-hmm. And there's a lot of that kind of reporting. Not to say that y'all are guilty of it, but I'm just saying it in the sum total of the news, especially true crime reporting, there's generally a tendency to take that side. And well, which side is more likely to sell newspapers? Probably the sympathetic side for the innocent person who is a victim of an awful offense than the terrible, evil rapist, murderer, whatever the character is. That already sort of sets up the tension. Now, again, chicken and the egg, the media does that in part because the public wants to side with the innocent victim and not with the criminal. And so I think the worry is just simply that there's no real respect in the public for the process itself. I mean, and it's a unique problem to the modern age. I mean, the reason we have galleries in courtrooms and the fact that in the old days, people that was their entertainment, before television. If you lived in the county seat, you go over and watch the murder trial, and then you go watch the hanging, I mean.
True crime 1.0 in that case.
Yes.
Exactly. But that was playing out in real time. The the people in the community may have heard about it. There may have been gossip and, murmur, and the guy down at the butcher shop says this, but to hear the story told, it's being told from start to finish, subject to the rules of evidence and the reason and discernment of a judge to filter out the stuff that we don't think is credible, and 12 people to ultimately decide the outcome, and everyone's watching that simultaneously. Now, because trials take a long time, and that process is frustrating, and the media wants people's attention now, we're going to try them in the court of public opinion first. And that's the problem. That's the issue, I think. I mean,
So right about now, and I mean, you've been there, you're a criminal defense attorney. Right about now, what is Brad Simpson's attorney trying to keep his client from doing and not doing while he's sitting in jail? Granted, he's sitting in a cell for 23 hours a day, but you can still do a lot of damage from inside that cell.
Oh, sure. Of all kinds, both physical damage and damage to your
Yes.
actual case, and
John's
damage
getting
to yourself.
flashbacks.
Yes.
Yeah, I mean, keeping his cool, trying to help him understand that it's a long process. I mean, like if you're taking a child on a road trip, you try to prepare them mentally. This is an 8-hour road trip. We're going to stop to go to the bathroom twice, but it's going to be a while. I need you to just be patient, and you try to get that concept set up in advance and often, because it's miserable. They have to sit in a car for 8 hours. This is that concept on steroids. He could be sitting for months, maybe years before this goes to trial.
True.
And he has to keep his cool. He has to remain patient. He needs to continue to listen to his lawyer's advice not to talk and maintain his Fifth Amendment privilege, unless he decides that it's in his best interest to cooperate, plead guilty. I mean, that's a strategy too. But assuming that his plan is he's going to try this case, he needs to keep silent. And then beyond that, it's about trying to help them think about what's going to actually materially benefit their case and what isn't. A lot of defendants have conspiracy theories about why things happened the way they did, why the arrest went down the way it did, where someone might actually be. This phone at this location has a text message that will exonerate me. Some of those things are just red herrings, and they waste the lawyer's time. So the next component is don't waste the lawyer's time. Like be brutally honest, be upfront. Let's be realistic about what we can and we can't accomplish. Because
yes.
Otherwise you spend months chasing some holy grail only to find out that it was just a dream.
The first story is always the best story, and then it gets progressively worse. It's like, I'm innocent, and then it's like, well, I also did this.
I'm innocent of
and
that.
Yes, exactly.
I like that one.
Exactly. So
What do you think? I mean, at this point, I'm watching the video. I was sitting in court. I'm looking for something. Down to the ground, look at the judge. Don't look at any of her friends. Don't look at your sister-in-law that's sitting in there. I mean, what do your clients tell you? What do they go through every time that they have to go to court? And they know they're going to face people that they're related to, that they know. What do your clients usually tell you?
Well, it varies widely between individuals. I mean, some people we have to kind of filter this out. If someone's guilty, they may be remorseless, or they may show an intense amount of remorse. If someone's not guilty, they may feel awful about the situation, because oftentimes people have put themselves in bad situations. They're just not legally guilty of something. So they may have residual guilt from that, and that affects their behavior, their demeanor, etc. But I mean, just, no one likes walking into a room and realizing that everyone in this room hates you. It's a really heavy thing, right? I mean, and most of the time in my life when I've had that happen, I think to myself, at least I hope that I'm imagining that some of these people hate me when they really don't. In a situation like this, there's no imagination. He knows that these people hate his guts. So how is he supposed to react to that? That's a very personal thing. I mean, I don't know if you can read. This is a big problem, right? I mean, you want to encourage. There was a lawyer, I forget the case. It was a high-profile case. the lawyer brought a coloring book and colored pencils for the man to work with during the
Oh,
trial
wow.
to keep his mind off of it,
Oh,
because
wow.
otherwise he would be reacting to the
Everything.
testimony, or
Everything.
and just freaking out and panicking. And I thought that was a good idea. Just like, try to go to your moment of zen.
Really?
Like, don't.
That's a good idea.
I think so. I mean, once people realize that you're coloring on a coloring book,
I think,
not so good.
I think back to the trial with the twins, or not the twins, they're brothers in California.
Oh, the Menendez brothers.
Yes, and the hangman, and I believe it was the prosecution or the judge brought that up. So that you say that, I mean,
Hangman's not the best game to play when you're at the council
Sure.
table. Yeah,
no,
definitely.
it's not. What's the next step as we're wrapping this up? What's the next step? Where are we going now? What's the next step in the hearing? I know they were talking about a next hearing. So what's next on the agenda?
So that next hearing is actually in relation to the custody, but as far as the criminal cases go, there is nothing on the case summary right now, but that makes me question, John, what is the next step in a case like this, at least from your vantage point?
Well, the next step for the lawyers will be the discovery process. And there will be delays in that because some of it's still in the hands of law enforcement, and the DA probably hasn't even seen it yet. It'll come in spurts, and as it comes in, they'll have to process all of that and go through it. As far as the court proceedings are concerned, the court will likely set it for some pretrial conferences or some docket calls where he'll just check in. How's discovery coming? Are you almost done? How much longer do you think it's going to be? What's outstanding in discovery?
Mm-hmm.
What efforts are you doing to make sure that we stay on schedule? If the defense thinks that there's something that the state has that they're not giving the defense, that they believe they're entitled to, they can file a motion to compel. Judge may take up some of those things. So lots of different things may happen, the timing of which is not really set in stone. But yeah, I mean, they could challenge the indictment. They could file a motion to suppress evidence that was illegally searched. They could do all sorts of things like that. The judge will probably set that for a hearing down the line.
Well, John, we appreciate you being here.
Always
Thank
a
you
pleasure.
so much. Your knowledge of the law and bringing it to a level that we can all understand, because it's very confusing. And there's a lot of people watching. Mariah, same thing. Mariah, by the way, passed the bar. So you do have that JD. I don't have the JD. I've just been around a long time. And we're going to continue on the story. We're going to continue following it. And we're going to continue asking the questions that need to be asked. The investigation's going on. Taxpayer dollars are paying for that. And there are children that still deserve to know what happened to their mother. From San Antonio, Texas, thank you for joining us. I'm Yami Virgen.